General and Legal Affairs.
Madam President, I thank you for the opportunity to make a contribution to this debate. A very important bill aimed at amending the Evidence Act, Chapter 702, to provide for the use of different identification procedures, interviews, oral submissions, special measures, and the taking of evidence by video link. That is the bill, Madam President, that is being debated here today. Madam President, and my most esteemed colleagues of the independent bench, do nothing, do absolutely nothing is the modus operandi of this opposition. So if we as a government are to pay heed to the noise by the opposition, nothing, absolutely nothing will happen in this country. This bill, Madam President, is not ad hominem. It is not directed to any particular person or any particular matter. This bill, Madam President, is an effort on the part of our government to continue in our crime-fighting strategies. The government of Trinidad and Tobago, Madam President, will continue to reject the noise of the opposition. We will continue to do the work of the people of Trinidad and Tobago with the support of the independents. We will act proportionally and in the interest of all our people. Madam President, for far too long, the law as it relates to adducing and admitting evidence for criminal matters has been unaddressed. The time to rectify this is now. The time to bring change, radical change to the law as it relates to evidence is now. And I call upon the learned senators in the independent bench to listen to what the Attorney General and all members of this government bench will present here today in an effort to convince each and every one of you that you can play a part, a significant part in radically amending and radically changing the criminal justice system of Trinidad and Tobago. As a government and a parliament, both the opposition as well and the independent senators, we have the power as the highest court of the land, to support legislation which will equip the police and the prosecution in the combat against crime. Madam President, I want the listening public to understand in a rather simple manner what is before this honorable Senate today. What our government, through our learned Attorney General, is attempting to achieve in this honorable Senate today. Madam President, I will simply build on areas of this bill which will radically improve the criminal justice system. The areas of this bill that I also as an advocate in a previous incarnation, also as an attorney at law who would have practiced in the courts of Trinidad and Tobago, also a practitioner of the criminal law, certainly believe that if these amendments are brought, it will certainly improve the manner in which we are able to bring remedies to the problems facing our criminal justice system. The areas of this bill, Madam President, that I'm particularly fond of and that I certainly believe will contribute significantly to improving the criminal justice system is as it relates to vulnerable witnesses and video link evidence, as alluded to by my learned colleague, Senator Hazel Thompson-Ahi, which I am in agreement with most of her points and her submissions, which I intend to adopt most of it. I would also contribute to the electronic evidence, the amendments brought to electronic evidence in Section 14B, the admissibility of CCTV evidence, which the learned Attorney General, because of time, could not totally develop, and aspects of identification procedures and offenses created under this bill. I want to say, Madam President, to Senator Lakshmi Dayal, I too practice in the courts of Trinidad and Tobago. I too was an advocate, and more so, I too was a defense counsel in a previous incarnation. Now where I stand, it's in a different position. It's in a different place. So I think I too am equally placed to understand what needs to be done to a great extent to improve the criminal justice system of Trinidad and Tobago. Madam President, I will begin by, if I can take my learned colleagues to Section 12AA of the Evidence Amendment Bill, which is before us here today, and also Section 12AD of the proposed section of the bill, which deals with video link evidence. These were sections, of course, that was dealt in great detail by my learned colleague, Senator Hazel Thompson-Ahi. But I have to make my contribution towards it because I believe this particular section, as included in this bill, will play a significant part in contributing to witnesses and people being willing to come to the fore and give evidence in criminal matters, which too often is one of the major hurdles that the prosecution often faces. Now, in a very simple term, Madam President, and this is for the benefit of Trinidad and Tobago, the layman who's listening, in a very simple term, this proposed section 12AA introduces special measures and vulnerable witnesses. Now, to the listening public, what is a special measure? Very simply, Madam President, a special measure is a direction issued by the court to facilitate a witness in the giving of evidence. And as adopted, I will adopt the position of my learned colleague, again, Senator Hazel Ahi, and to avoid tedious repetition, that particular section, of course, would have identified Section 12AA subsection 2, would have gone into details as to what the court must be satisfied of in subsection A and B as to what determines a vulnerable witness. And to my mind, this is a very, very fair procedure because the court must be satisfied that A, subsection A, the witness is vulnerable, and B, that the quality of evidence given by the witness is likely to be diminished by reason of fear or distress. So if I may develop this for the listening public from a very layman's perspective, sometimes as attorneys at law, as advocates, you will sit in a conference room with your client. And because it's you and your client alone, the client is very, very open. The client is very open about events that would have transpired in a particular incident. But for some reason, from the time that very same client is placed in an open court setting, because of the very intimidation of that court setting, what you may find is that the nature in which they give evidence is severely compromised. And that sometimes very well goes to the credibility of this witness now in an open court setting. The reason why I'm reiterating this in a very simple form is for Trinidad and Tobago to really understand what the government is trying to achieve today. We want to put in, we have brought amendments that can only significantly contribute to persons in Trinidad and Tobago, witnesses being willing to come to the fore and give evidence, because we understand sometimes a lot of matters are lost in the courts as a result of insufficient witnesses. A learned senior counsel or learned defense counsel, through the tact of cross-examination, can mash up a witness who is fearful of a normal court setting. I have seen that on many occasions. And what this amendment, as simple as it may seem, it stands to contribute significantly to improving our criminal justice system. Now, I remember, Madam President, in the case of Dole Chedi, which is Nanki Soon Budram et al. Against the state. Now, this particular case would have contributed significantly on many areas of law. But I remember in that case, in the obita by Justice De La Bastide, Justice De La Bastide stated that in a jurisdiction like ours, witnesses are often murdered and they refuse to testify because they are afraid. Trinidad, Madam President, is such a small country. Given this small geographical area, there is a likelihood that you always know somebody who knows somebody. And I respectfully submit to this Honorable Senate that this provision, as simple as it may appear, it carries significant weight to certainly change the trajectory of the criminal justice system in Trinidad and Tobago. And that is why I started from the onset by saying that I agree with the Honorable Senator Hazel Thompson-Ahi about the importance of this simple amendment and what it stands to bring to the people of Trinidad and Tobago. Now, Madam President, if I may take the Honorable House to section 12AD of the evidence of the bill which is before us today. Now, this particular section, Madam President, it deals with the use of video link evidence. And video link evidence, as we stated before, is a type of special measure that upon the application of the court can be granted. So what it means, it can be granted. So what this simply means is that either a prosecution or defense counsel can go to the court at a CMC stage, because again, through our learned Attorney General, we have already have rules of the criminal court being introduced. So at a CMC stage, very practically, an application can be made by counsel, defense, or prosecution for the use of a video link evidence, again, as it relates to vulnerable witnesses. But the court does not make this decision willy-nilly. The court, of course, will assess, the judicial officer, which being the judge, will assess the matter which is before her or him before such a decision is made. So certainly, even relative to applications being made for video link evidence, there is a level of due process in the application. So therefore, we don't have the rights of even the accused being trampled upon. And the learned Attorney General was specific when drafting this particular piece of this amendment to ensure that those rights, even of the accused, was not trampled upon. Now, Madam President, the use of video link evidence, if I may respectfully submit, in this particular jurisdiction, as most of my colleagues who are attorneys at law would know, is governed by the common law. We are still in a rut as it relates to the use of video link evidence because of the principles in Aaron Davis and Aaron Ellis. Now, this decision, which is highly persuasive, the decision in Aaron Ellis and Aaron Davis, now Davis went straight up to the House of Lords. And in this particular decision, what the court would have stated was that the use of video link evidence would have severely compromised the fairness of the trial. So in that case, that statement was made up. It was made that video link evidence, and in this particular case of Aaron Davis, voice modulation was used as well for a witness. And the court did agree at that level that it affected the fairness of a trial in Aaron Davis. But what is an important obita, what is an important learning that came out of that case is that the House of Lords deferred to the Parliament to intervene in cases in long-standing common law as it relates to the status and exposure of vulnerable witnesses. So while in that case, the court did say that the fairness of a trial may have been impacted upon, the court deferred to the Parliament and said, listen, in essence, you are the highest court of the land. You have within your hands the power to bring legislation that will diminish common law principles that stand as a blockade to criminal justice. And that, Madam President, that members of this honorable house is what we are attempting to do here today. So by reference to this particular section, we as a parliament, we have come here to remove common law blockades that exist in our judicial process. We are here as a parliament to, of course, bring law, statute, that is now going to take precedent over any common law principle. And of course, give the police, give the prosecution the teeth that it needs in order to bring an end to crime in this country. Now, Madam President, I would now like to go to part 3, which is clause 6 of the act, the bill, which is before us. This, Madam President, I believe this particular section, I believe is fundamental. And it is so crucial, again, as I may sound repetitive, to improving the criminal justice system. Because, Madam President, it refers to evidence by electronic records. Now, the question is, for the layman again, and for the benefit of the non-lawyers here, the act itself, the bill itself speaks to what is an electronic record. Now, electronic records, in summary, it's a record generated, communicated, received, stored by electronic means in an information system or for transmission from one information system to another. Information meaning data, text, images, sounds, codes, telephone communication. In this country, everyone, and in the world, everyone has a phone. And people use their phone as ammunition. I got videotape here. I get a tape of it. I have a picture
Minister,
of it.
you have 5 more minutes.
Wow. Okay, Madam President. This particular section, Madam President, it is crucial because why? It means that these things that we can take on our phones is now admitted and can be admitted into evidence. Before we often threaten people that I have a recording and I have a video and I have this. Under the previous section, Madam President, it was a very high standard that had to be proven before such recording, such electronic records could be deemed as admissible into court. What the court would have to, what counsel who intends to adduce that as evidence or admit that into evidence would have to prove, of course, they would have to prove the workings of the device which was used in order to be able to capture that information. And what you would have, and I have seen personally, because in a previous incarnation, I believe, and I will say publicly, that I practiced one of the best criminal attorneys in this country, Pamela Elder Senior Counsel. And I have seen, and I have personally witnessed, where my senior was able to destroy evidence by the prosecution because of their inability to lay that crucial foundation in proving the workability of the device. This act in Section 14, by repealing Section 14 and the new inclusions that have been made, this is fundamental because the workability of the device is going to be presumed as working well. And then, of course, the sections, of course, goes on to speak to, if there is a doubt, there are sections, of course, that goes on to speak to, yes. So if, however, there's a challenge as to the workability or the workings of the device, correct. So therefore, there's still a process, there's still due process which applies to this particular section. All right? But, Madam President, I respectfully submit, and I know time is of the essence now, Section 14B is crucial to this bill, and it's a very important piece of legislation that we have brought to the House today, and I serve to the Senate today, and I would passionately say that it stands to contribute significantly. It stands to contribute significantly to the manner and the type of evidence that we are now allowed to enter and to admit into court proceedings. Very quickly, Madam President, the Learned Attorney General would have focused on CCTV recordings. This is dealt with in Section 12AH of the bill which is before us. If I must say, Madam President, this particular amendment is a significant step in the government's commitment to the digitization of our nation. There are several ways in which CCTV could be used, especially in criminal justice outcomes, and it can also be used significantly in civil proceedings as well. When we think of how many matters that clog our judicial system based on road accidents and road fatalities, CCTV can play, and the admissibility of this CCTV evidence can certainly play a crucial role in bringing an end to some of these matters where liability is being challenged. So, of course, we have also taken that into consideration. And if I may finally look at Section 12Z of the evidence bill, which is up before us. This is Part 6. This deals with the issue of offenses. Now, what we have, to whom much is given, much is expected. And I believe this has been the modus operandi of our Learned Attorney General. When every piece of legislation that has been created, mechanisms have been put into place. So, want of a better word, when you ask who will guard the guard, these provisions are put in here to ensure that this happens. So, for example, these offenses that have been created, the proposed Section 12Z, which creates the offenses. Under this new law, a person who disseminates, copies, modifies, or even erases recordings in an interview without lawful authority commits an offense and would have either to pay a fine of 100,000 or to be imprisoned or pay a fine for 2 years, or pay a fine of 500,000 or face 7 years of imprisonment. So, of course, this offenses, by increasing offenses and including offenses, we're ensuring that the police is now liable, that the court staff is now held liable. That is in order to, of course, maintain the integrity of the evidence. So, in closing, Madam President, as a parliament,
Your time has expired.
Thank you very much, Madam President.
Senator Rambajan.